Hello, my name is Christian Thompson, and I am a managing partner at the Franchise and Business Law Group. And today we're going to be talking about financial conditions, particularly what's called an impound or an escrow. So this is where a state has imposed a financial condition in order to register in that state to be able to sell franchises. So let's say Washington. You want to register in Washington. And Washington comes back and says, yes, you can register if you, we talked about it before, but it's defer fees, put the money in escrow, or purchase a surety bond. So right now we're just going to be talking about impound and escrow. So basically what this is the franchisee will pay you, the franchisor, that initial franchise fee, and anything, let's say inventory or something like that, that has to be paid to the franchisor and affiliate. That money will, instead of going to the franchisor, or it could go to the franchisor, but then immediately after it gets put in escrow. So this is set up by a third-party independent bank. Usually it's a state bank or a national bank, and they put that money in an account, and it just sits there. And it sits there until the franchisor has provided or performed all of its pre-opening obligations to the franchisee, and the franchisee is open for business. So after that, those two conditions are met, the franchisor then notifies the state, and then the state of Washington will send a letter or give notice to the bank, and the bank then can release the funds. So it's a bit of a process, and we'll go over the advantages and disadvantages here in a minute, but that's one of the options that franchisors have to comply with the financial condition. So the advantages of this is that the money actually gets paid. So a fee deferral, the disadvantage of that is that the franchisee doesn't pay any money, and there is a chance that the franchisee may never pay any money. So here at least the franchisee pays that amount in. The disadvantage is, again, that the franchisor does not get any of this money until the franchisee is open for business. So if it costs money to get the franchisee open, trained and things like that, that is all on the franchisor's dime. They can't use any of the money that's put in escrow for that. Likewise with inventory and things like that are purchased from the franchisor or an affiliate, that has to be covered by the franchisor or an affiliate. Second disadvantage is that it's kind of costly. So not many banks like to do this, and so banks will charge $1,000, $1,500 up front to set it up, and then they'll charge that same amount for each time you do it in the state, and then there's attorney's fees to get it set up and things like that. So this is a safer route than fee deferral, but it does cost some money. So we at the Franchise and Business Law Group, we're very familiar with financial conditions and helping our clients navigate financial conditions imposed by states. So please give us a call. We'd love to help you. Go to our website and we'll schedule an appointment.